When pharmaceutical giant Allergan transferred its most valuable patents to the Saint Regis Mohawk Tribe in September 2017, the company claimed it was simply seeking to protect its intellectual property from an expensive legal challenge. But what Allergan really did was exploit a loophole in federal patent law so brazen, so unprecedented, that it would ultimately spark congressional hearings, federal investigations, and a complete rethinking of how Native American sovereignty intersects with corporate America's patent games. The drug at the center of this scheme was Restasis, a blockbuster eye drop treatment for dry eyes that generated over $4 billion in revenue for Allergan. With generic competition breathing down their necks and patent challenges mounting in federal court, Allergan's executives devised a plan that would take corporate legal maneuvering to an entirely new level of audacity. Restasis wasn't just any pharmaceutical product for Allergan. Since acquiring the drug through its merger with Advanced Medical Optics in 2010, and later through additional acquisitions, Allergan had built Restasis into one of its most profitable franchises. The drug contained cyclosporin, an immunosuppressive agent that helps increase tear production in patients with chronic dry eye disease. By 2017, Restasis was generating approximately $1.5 billion in annual sales for Allergan, representing roughly 10% of the company's total revenue. The drug's success was protected by multiple patents that weren't set to expire until 2024, giving Allergan what appeared to be years of monopoly pricing power. But appearances can be deceiving in the pharmaceutical industry, where patent challenges are as common as clinical trials, and generic drug manufacturers had been circling Restasis like vultures for years. The threat to Allergan's Restasis empire came through something called an inter partes review, or IPR, a relatively new legal mechanism created by the America Invents Act of 2011. IPRs allow third parties to challenge the validity of patents before the Patent Trial and Appeal Board, known as PTAB, rather than going through expensive federal court litigation. These proceedings are faster, cheaper, and historically more successful for challengers than traditional patent lawsuits. Generic drug manufacturers had filed IPR petitions challenging 6 key Restasis patents, arguing that the patents were obvious and therefore invalid. If PTAB ruled in favor of the generic companies, Allergan could lose patent protection years before the scheduled expiration dates, opening the door for generic competition that could devastate Restasis sales virtually overnight. Industry analysts estimated that successful patent challenges could cost Allergan hundreds of millions of dollars annually, as generic versions flooded the market at drastically reduced prices. Faced with this existential threat to one of its most valuable assets, Allergan's legal team came up with a strategy that no pharmaceutical company had ever attempted before. They would transfer ownership of the Restasis patents to a Native American tribe, then have the tribe claim sovereign immunity from the IPR proceedings. The legal theory was complex but potentially powerful, since Native American tribes possess certain sovereign immunity rights similar to state governments, and since state governments had been ruled exempt from IPR challenges in a 2015 Federal Circuit decision, tribal ownership might shield the patents from PTAB review entirely. If successful, this maneuver would effectively kill the generic company's patent challenges without Allergan having to prove their patents were actually valid. The plan required finding a tribal partner willing to participate in what would inevitably become a highly controversial and closely scrutinized transaction. Allergan found their partner in the Saint Regis Mohawk Tribe, a federally recognized tribe with territory spanning New York State and Canada. The tribe's motivations for entering this arrangement were straightforward: economic necessity and the promise of substantial ongoing revenue. Like many Native American tribes, the Saint Regis Mohawk faced significant economic challenges, with limited opportunities for generating revenue on their reservation lands. Allergan offered them an immediate payment of $13.75 million for acquiring the patents, plus annual licensing fees of $15 million for as long as the patents remained valid and enforceable. For a tribe with an annual budget of approximately $28 million, This represented a transformative financial opportunity that could fund essential services and economic development for years to come. The agreement was structured as a sale and license-back arrangement. The tribe would own the patents and immediately license them back to Allergan for continued commercial use. The transaction was announced on September 8, 2017, and the reaction was immediate and overwhelmingly negative. Patent attorneys, pharmaceutical industry experts, legal scholars, and federal lawmakers condemned the deal as an abuse of tribal sovereignty and a perversion of patent law. Critics argued that Allergan was essentially weaponizing Native American sovereign immunity for purely commercial purposes, using tribal status as a shield to avoid legitimate patent challenges rather than respecting sovereignty as a matter of tribal self-determination. The arrangement appeared to create a dangerous precedent where any company facing patent challenges could simply transfer their intellectual property to a willing tribe and claim immunity from federal patent proceedings. Legal experts questioned whether such transactions would hold up under judicial scrutiny, noting that the Supreme Court had generally required a more direct connection between sovereignty claims and core governmental functions. The Patent Trial and Appeal Board was forced to grapple with this unprecedented situation when the Saint Regis Mohawk Tribe formally moved to dismiss the pending IPR proceedings, claiming sovereign immunity as the new patent owner. The generic drug companies opposing the patents argued that tribal immunity shouldn't apply to IPR proceedings, which are administrative rather than judicial processes, and that allowing such immunity would create a massive loophole in patent law that could be exploited by any company with sufficient resources to partner with a tribe. They also contended that the transaction was purely a legal fiction designed to circumvent legitimate patent challenges, noting that Allergan retained all meaningful control over the patents through their exclusive license agreement. The stakes were enormous. If the tribe's immunity claim succeeded, it could spark a rush of similar transactions across the pharmaceutical industry and fundamentally alter how patent disputes are resolved. While the PTAB deliberated, criticism of the Allergan-Saint Regis Mohawk deal intensified across multiple fronts. Senator Claire McCaskill, then the ranking member of the Senate Homeland Security and Governmental Affairs Committee, announced an investigation into the transaction and called for hearings on whether federal law needed to be changed to prevent similar arrangements. Patent attorneys warned that allowing such transactions would undermine the entire IPR system, which had been designed to provide an efficient mechanism for removing invalid patents from the system. Some Native American legal experts expressed concern that the deal could ultimately harm tribal sovereignty by creating a backlash against legitimate immunity rights, potentially leading to congressional restrictions on tribal sovereign immunity more broadly. The pharmaceutical industry itself was divided, with some companies quietly exploring similar arrangements, while others worried about the long-term consequences for patent law and tribal relations. In February 2018, the Patent Trial and Appeal Board delivered its decision, and it was a complete rejection of Allergan's strategy. The PTAB ruled that tribal sovereign immunity did not extend to IPR proceedings, distinguishing these administrative patent challenges from traditional court litigation. The board noted that IPR proceedings were designed to be faster and more efficient alternatives to federal court patent challenges, and that allowing immunity claims would undermine the entire system Congress had created for reviewing patent validity. More damaging to Allergan's position, the PTAB suggested that the transaction appeared to be primarily motivated by a desire to avoid patent challenges rather than any legitimate business purpose related to tribal sovereignty. The decision allowed the generic company's patent challenges to proceed, putting Allergan right back where they started, but now with the added burden of having paid the tribe $13 7/5 million for patents that couldn't be shielded from review. Allergan's defeat at the PTAB was just the beginning of their problems. In October 2018, the Federal Circuit Court of Appeals upheld the PTAB's decision, delivering an even more scathing assessment of the patent transfer scheme. The appeals court ruled that even if tribal sovereign immunity could theoretically apply to IPR proceedings, the specific circumstances of the Allergan-Saint Regis Mohawk transaction were insufficient to trigger such immunity. The court noted that Allergan retained all meaningful rights to the patents through their license agreement, including the right to enforce the patents and collect all revenues, making the tribal ownership largely nominal. The Federal Circuit's decision effectively killed any hope that similar transactions could provide meaningful protection from patent challenges, sending a clear message to the pharmaceutical industry that courts would look beyond formal ownership structures to examine the substance of these arrangements. The broader consequences of Allergan's failed gambit extended far beyond the immediate fate of the Restasis patents. Congressional lawmakers introduced legislation specifically designed to prevent similar transactions in the future, including bills that would explicitly exclude intellectual property licensing transactions from tribal sovereign immunity protections. The Patent and Trademark Office began studying whether additional regulatory changes were needed to address potential abuses of the patent system involving tribal sovereignty claims. Legal scholars debated whether the decision struck the right balance between protecting legitimate tribal sovereignty rights and preventing corporate abuse of those protections. The pharmaceutical industry largely abandoned any plans for similar transactions, recognizing that the legal and reputational risks far outweighed any potential benefits. The Saint Regis Mohawk Tribe, meanwhile, continued to receive their licensing payments from Allergan under the terms of their agreement, even though the patents they owned offered no immunity from federal patent challenges. The ultimate irony of Allergan's elaborate patent thicket strategy was that it drew unprecedented attention to patents that might otherwise have survived their validity challenges. The controversial nature of the tribal transfer scheme put the Restasis patents under intense scrutiny from patent attorneys, generic drug manufacturers, and federal regulators who might not have focused so intensely on the underlying intellectual property without the sovereignty controversy. When the PTAB finally ruled on the merits of the patent challenges in May 2018, they invalidated all of the challenged Restasis patent claims, finding them obvious over prior art. This outcome represented a complete disaster for Allergan. They had paid millions of dollars to the Saint Regis Mohawk Tribe, generated enormous negative publicity, sparked congressional investigations, and ultimately lost their patent protection anyway. The company's stock price fell sharply on news of the adverse patent ruling, wiping out billions of dollars in market value as investors calculated the impact of imminent generic competition on Restasis revenues. By 2019, multiple generic versions of Restasis had entered the market, driving down prices and eliminating the monopoly profits that Allergan had so desperately tried to protect through their tribal immunity scheme.